Cyber law. So firstly, we will see what is the meaning of cyber and law. Then we combine cyber law. The term cyber or cyberscape space has today come to signify everything related to internet, website, networks, email, data, computer, storage, software, and even airplane, ATM machine, biometric devices, CCTV cameras, drones, smartwatches, smartphones, e-commerce, online shopping, and many more. So basically, cyber is related to computer and network. We can say in short, computer and internet. Because now there's biometrics, CCTV, that is the embedded system of computer and internet. Main thing is computer and internet. So we can say cyber is related to computer and internet. Then law, we can say rules. What is law? Have been approved by government. Law must be approved by government. It can be in certain territory. The boundary will be fixed. Any law have certain boundary territory, which means which must obeyed by all person on that territory. We can say all person of that region. Violation of these rules will lead to government action such as imprisonment or fine or an order to pay compensation. So if somebody break the rule, volatile the rule, then government take action against them. So now cyber is related to computer and internet. Law is related to rules that is approved by government. So now cyber law. Cyber law is the law governing cyberspace. If we uh, say about traditional law, that is law governing by government in certain state. So now cyber law is law governing by cyberspace. When we live in cyberspace means we use cyber like social media, online shopping, electronic, we can say electronic platform. Then law, some rules, some laws will be applied. So law governing the cyberspace known as cyber law. Why cyber law is related to, for example, our traditional laws related to crimes, ठीक है, crimes, violation of somebody rights. So similarly, cyber law relates to cyber crime. Means when cyber law comes, when cyber crime occur, electronic and digital signature, when somebody misuse electronic and digital signature, intellectual property, data protection and privacy. So first one is cyber crime. When cyber law is applied, then cyber crime occurred. So cyber crime covered computer crime, computer related crime, computer abuse. So any violation of specific law that related to computer crime. Then computer related crime means knowledge of computer technology. Somebody misuse knowledge of computer technology. Violation of criminal law that involve a knowledge of computer technology for their investigation and prosecution. Computer abuse, intentionally act that may or may not be specified prohibited by criminal statutes. Any intentional act involving knowledge of computer use or technology is computer abuse. So computer abuse means basically, for example, if you pick any image and edit it and post, then you intentionally use knowledge of computer means knowledge of editing, and due to this it hurt somebody, it comes under computer abuse. We can say when we try to abuse, try to hurt somebody with the help of computer knowledge, that is known as computer abuse. Then electronic and digital signature. The term electronic commerce is used to refer electronic data used in commercial transactions. As we know, electronic commerce means online shopping that use electronic data. When you place your order, that will be stored in electronic form. You have no any paper slip when you place an order. Okay? So e-commerce is used to refer electronic data used in commercial transaction. Electronic commerce law usually address issue of data authentication by electronic or digital signature. When you buy anything online, your parcel have some barcode. We can say electronic data. So that barcode identify the authentication. For example, you buy any product from Flipkart, then that barcode is data authentication of Flipkart. But if somebody try to use that authentication, that comes in under electronic and digital signature law. Intellectual property. Intellectual property means your asset. So it copyrights, trademark, patent law, that comes under intellectual property. Means when somebody try to use your property, that laws will be help to you. Copyright law, for example, you develop any website, you have copyright. Somebody try to use your website, you can take any action, you can file a case in cyber cell against that. You can prove that you have copyright, you are the owner of this product. So copyright law relation to computer software, computer source code, website, cell phone content. Then software and source code license. We hear about window license, some software license. So software license and source code license comes under this law, intellectual property law. For example, Microsoft Windows have license. Mac try to sell as their product. Then this law will help Microsoft to take any action against Mac. Trademark law, which with the relation to domain name, meta tag, mirroring, framing, and linking. Semiconductor law, which relate to protection of semiconductor integrated circuit design and layout. Semiconductor law deals with the hardware, we can say. As we know, motherboard have some design layout. For example, Dell design a motherboard means integrated circuit design and layout. No other company can use their design and layout without permission. If some company try to do this, then criminal cyber crime for a case will be filed against them. Then patent law in relation to computer hardware and software. Patent software means when we use software without paying to the owner, without permission of owner, that comes under patent software. So patent law helps to take action against them when somebody try to use their information, hardware, software without permission, without paying. Then data protection and privacy. Data protection and privacy laws address legal issues arising in collecting, storing, and transmitting sensitive personal data by data collectors, such as banks, hospital, email server provider, etc. For example, Zoom app. Data of app is hacked by someone. So these crimes comes under data protection and privacy because their data is not protected. So now categories of cybercrime. Firstly, we will see what is cyber law, then where cyber law applied. So now cybercrime, because due to cybercrime, cyber law evolved. So now categories of cybercrime. Cybercrime against person. So we can say any crime that hit a particular person, like cyber stalking, impersonation, loss of privacy, transmission of obscene material, harassment with the use of computer. Then cybercrime against property. We can say when cybercrime hits any company, organization, any business. So which type of crimes comes under cybercrime against properties? Unauthorized computer trespassing means computer use, computer destruction, we can say virus, uh, worms, transmission of harmful programs, softening of funds from financial institutions, stealing secret information and data, copyright. Cybercrime against government. So any crime in cyberspace that affect government, hacking of government websites, cyber extortion, cyber terrorism, computer viruses, and some other cyber crime, logic bombs, spamming, virus, bombs, Trojan house, email bombing, and email abuse, etc. So these are the some categories of cyber crime. So next topic is need for cyber law. Why cyber law evolved? What is the requirement of cyber law? So in today techno-savvy environment, the internet is treated as a research and information sharing tool. Since the number of internet users is on the rise, it gives birth to cybercrime. So nowadays we know technology environment means information technology environment, we can say even a small business involved information technology means now even we just buy a cup of tea, then we can pay Google Pay, Paytm, means we can use electronic data transmission. So in today techno savvy environment, we can say information system environment, number of users is on the rise, means large number of people use cyberspace, we can say. Even if we see in our class 43 student, so from 40 student there is probability that above 35 student will use cyberspace. It give birth to cybercrime. So there can be some cyber crimes like we use online payment. So there is many cases we hear about uh, fraud of money from our accounts. All the issues related to cyber crime or internet crime are dealt with through cyber law. So the crimes related to cyberspace can be dealt with the help of cyber law. So to get the remedy against cyber crime means to solve, to reduce, to eliminate cyber crime, the need for cyber law arise. So that's why cyber law evolved. As per rules and regulation of cyber law, a person who commit a cyber crime is liable to get punishment. As a traditional law, if somebody do some crime, government will take action against them. It can be imprisonment or fine. Similarly, in cyberspace, if an criminal commit any cyber crime, is eligible to get punishment. If anyone violated and break the provisions of the law, then it allow another person or organization to take legal action against that person. Means if somebody fraud money from our bank account, we can take action against that person. Any person or organization can take legal action against that person. So the requirement of cyber law can arise as under. Nowadays, all transactions related to shares are done in DMART form. DMART form is electronic record. Anyone who is associated with these transactions require internet and protection under cyber law in case of any fraud transaction. So nowadays we see when we withdraw money from ATM, the entry of our withdraw amount in our account entered in electronic record. For example, you withdraw some money from your account ATM, and then immediately you log in your net banking and check your amount is detected, and entry of that record is here. That is due to electronic record, means computer and internet. So nowadays all of the transactions are related to DMART form. So if there is any fraud, sometimes we does not receive money, but it detected from our account, and when we call to the care center, they tell to us that your amount will be refunded in few days. So, and in case of fraud transaction, we can take help from cyber law. Most of companies in India keep their official data in electronic form. For example, colleges, hospitals, most of the hospital keep their record in electronic form. To avoid the misuse of such data, a company can need assistance of this law. For example, if some company, some organization data is tapped by somebody, so there can be misuse of that data. So company can be take help from cyber law. Due to rapid growth of technology, various government forms like ITR return, income tax return, we can say, service tax return are filled in electronic form. Anyone can be hacking the government portal sites easily, misuse these forms. Only under cyber law, you are eligible to get a remedy against this type of fraud. So nowadays, uh, many government forms are filled online. So some hacker can hack government website and misuse your data. So in that case, government and you can take any action against criminal under cyber law. People are using credit cards and debit cards for shopping purpose. However, some frauds through the internet clone those credit cards and debit cards. Card cloning is technique where someone is the help of internet easily obtained your card details. With the help of cyber law, you can easily trace such criminals. For example, when you try to shop online, uh, when you click on submit, it redirects to the hacker website, and same page of that looking like a bank page display to you, and you again enter your details, and when you click on submit, your detail are transferred to the criminal. So in that case, you can trace, you can complain your fraud in cyber cell, and cyber cell will trace the criminal. So with the help of cyber law, we can easily trace such criminals. Then digital signature and e-contracts are most common method of transacting business. Anyone who is associated with such digital signature and e-contracts can easily make fraud by misusing them. Cyber law protects you against such type of fraud. For example, you apply for license. So we hear about that some cafe can provide a duplicate license, means by using digital signature electronics. Similarly, all the format they follow and can provide duplicate documents. So in case of these frauds, we can take help from cyber law. This is all about need of cyber law. So the main need of cyber law is we can take action about crime that will happen in cyberspace. So our next topic is cyber jurisprudence at international and Indian level. So firstly, we will see what is cyber jurisprudence. It is study of laws which is directly related to cybercrime. We can say cyber law is a law that apply on cybercrime. The study of laws, we can say study of all criminal laws which is directly related to cybercrime is known as cyber jurisprudence. So at Indian level, so in Indian level, we will see which is different acts that helps in cyber crime at Indian level. So in India, at centralized statute, actually for cyberspace has been enacted with the in the form of Information Technology Act 2000, which come in force on 17 October 2000. So at Indian level, main act is 2000, Information Technology Act 2000. It also mentioned in our syllabus section A at last, IT Act 2000. So it launched on 17 October 2000. This act is to the act and umbrella legislation of Indian cyber crime. We can say all laws comes under Information Technology Act 2000. As stated in preamble, the IT Act is to provide legal recognition for transactions carried out the mean of electronic data exchange interchange. We deal with cyber, means data come in electronic data. So all legal recognition for transaction carried out in electronic form and other mean of electronic communication refer to electronic commerce, which involve the use of alternatives to paper-based method of communication and storage information. It is the alternative way to the paper-based, means in previous years, bank use paper, mean check is filled paper, although it is possible nowadays, but now we can use electronic check. So paper is replaced with electronic form. So alternative use of paper based. So all the transactions carried out in electronic data, electronic form, and we communicate electronically to facilitate electronic filling of document with government agencies, and further to amend the Indian Penal Code, Indian Evidence Act, Banker Book Evidence Act, Reserve Bank of India Act, and the for matters connected therewith to incidental thereto. So basically, Information Technology Act deal with the legal recognition of electronic form communication. So Indian Penal Code, Indian Evidence Act, Banker Book all comes under in IT Act 2000. We can say it contain all the features of Evidence Act, Banker Book, Penal Code, Reserve Bank of India Act, etc. Further, the act is to promote efficiency delivery of government service by means of reliable electronic records. So basically, it used to provide efficient delivery of electronic record. So now let us understand about Indian Penal Code, Indian Evidence Act, Banker Book Evidence Act, and Reserve Bank of India. The first one is Indian Penal Code. Cybercrime can involve criminal activities that are traditional in nature, such as theft, fraud, forgery, defamation, and mischief, all of which are subject to Indian Penal Code. Basically, Indian Penal Code deal with theft, fraud, forgery, defamation, and mischief in traditional. But as we know, in the Information Technology Act deal with the electronic form. So nowadays, theft, fraud, forgery can be occur in electronic form. So Indian Penal Code, in this theft, fraud, forgery, defamation, mischief done in electronic form will be covered in Information Technology Act. The abuse of computers also has given birth to the mode of new age crime that are addressed by Information Technology Act. So Information Technology Act 2000 use the feature of penal code, means it deal with the theft, fraud, forgery, defamation, and mischief. Then Indian Evidence Act, it launched in amended in 1872. So what is the main objective of Indian Evidence Act that is adopted by Information Technology Act 2000? To provide legal recognition for transaction carried out by the mean of electronic data interchange and other mean of electronic communication, commonly referred to as electronic method of communication and storage of information, to facilitate electronic filling of documents with the government agencies and further too. So Indian Evidence Act, it keep detail of all actions carried out. Means for example, you opened your account, you deposit 1000. So record 1000 means from which bank that is. Then you withdraw 500. So it keep all the evidence. So Information Technology Act 2000 take the objective of Indian Evidence Act also. Then Banker Book Evidence Act. Firstly, read the second point. Later, an account book or record book showing the transaction of a bank. In previous years, in older days, there was ledgers, we can say, a bank book, we can say, that keep record of all transactions. But nowadays, book used as evidence in court of law, and we can say in electronic form. The Banker Book Evidence Bill was passed by legislature on 1st October 1891. According to this act, in all legal proceedings, a copy of an entry in Banker Book such as transaction accounts shall be treated as prima facie evidence of such entry. So Banker Book means entry of all transactions. Then Reserve Bank of India Act 1934, it can provide loans to bank and state financial corporations. It can provide advances to central government and state government. It can buy or sell government securities. Uh, as we know, Reserve Bank of India can give loan to the state government as well as central government. It can sell or buy government uh, assets. It has also empowered that center board that has been constituted by Reserve Bank of India to regulate fund transfer via electronic means provided by banks or other financial institution based on the Reserve Bank of India Act 1934. So all the financial, we can say, activities, transformation of funds from to central government, state government, or people are comes under Reserve Bank of India. And Information Technology 2000 Act deal all things in electronic form. So basically, Information Technology Act 2000 is deal with cyber crime, we can say cyber data. Then issues of jurisdiction in cyberspace means study of law in cyberspace may problems in cyberspace. Jurisdiction gives power to appropriate court to hear and case and declare and judgment. Jurisdiction, a law, we can file our case in court and court can declare their decision, judgment. In cybercrime instance, the victim and accused are generally from different countries. So in cybercrime, both victim and criminal can be from different countries. For example, victim are from India and criminal are from other country like UK. Hence, deciding which jurisdiction will prevail is conflicting. So here problem is which court, which country declare judgment. The internet, as stated earlier, has no boundaries. Such no specific jurisdiction can be titled over its use. So now we nowadays we know there is no boundary because we can talk with the person from different country. So there is no boundary. So there is no specific jurisdiction. For example, criminal from UK and victim from India. So there is no, we can't decide which country take decision. A user is free to assess whether he wishes to and from when wherever he wishes to. Means we are free, we can talk, we can communicate with any person over the world till the time a user online activity is legal and not violative of any law. Then there is no issue. Means if we work in cyberspace but doesn't take any crime, doesn't do any criminal activity, then there is no issue. But when such action become illegal and criminal, when there is some illegal actions, criminal activities, then jurisdiction has a crucial role to play. So now, for example, a user committing a robbery in country A while sitting in country B from the server of country C, then which country jurisdiction will apply need to answer in case the transaction might have done virtually. Yet the people are present physically in their respective countries governed by their law, and the court generally decide the jurisdiction of country where a crime has been actually committed. For example, a person at India take robbery means take a money from account of USA, but it use account of means identity, we can say server of you Australia. So now the main problem is which jurisdiction means which government will take action, India, USA, Australia. So this is the main issue in jurisdiction in cyberspace. In cyberspace, there are generally three parties involved in a transaction. When any transaction performed, there will be three entities: user, server host, and the person with whom that transaction is taking place. For example, we buy anything from Flipkart. So user, we are the user. Server host means our bank server, we can say, for example, HDFC. And bank person with whom the transaction is taking place means Flipkart. So generally three parties are involved in the transaction, which need to be put within one jurisdiction. So if there is any fraud, then these three parties can be comes under a common jurisdiction. All three parties in all as to belong to their different countries. Now laws of A, B or C will be prevalent or not, or even municipal laws will be applicable, or international laws are issue of jurisdiction in cyberspace. The extent of court competency to hear a cross-border matter and apply the domestic state law is another issue. So basically, all three entities parties can come under a common jurisdiction. If the user from different country, host from the different country, and the person with whom the transaction is taking place are from the different country, then there can be problem if any crime occur in cyberspace. So then our next topic is type of jurisdiction. So there is a three type of jurisdiction: personal, subject matter, and pecuniary jurisdiction. First one is personal jurisdiction. It is the type of jurisdiction where the court can pass judgment on particular parties and persons. In this type, when any case filed in court give their judgment on based on person. The Supreme Court of US. So now there is a example, we can say any case study. The Supreme Court of USA observed that the due process contained in Constitution of US contains the personal jurisdiction upon its implication on non-resident. Hence, there is no direct jurisdiction on non-resident. However, this restraint was covered over by minimum contact theory, which allowed the jurisdiction over non-resident as well. So here in section 2, we have a topic minimum contact theory and sliding scale theory. So there we will learn about minimum contact theory in detail. So personal jurisdiction pass judgment on particular person, but there is a problem for non-resident means which are the person are not belong to that reason. So there are no direct jurisdiction on non-residents in case of personal jurisdiction, which solved by minimum contact theory later. So main meaning of personal jurisdiction is judgment on particular person, means based on person. Then subject matter jurisdiction. It is a type of jurisdiction where court can hear and decide specific case that include a particular subject matter. So this is based on subject. The personal is based on personality, we can say, based on person, and based on person jurisdiction take decision. But in case of a subject, jurisdiction take decision that include particular subject matter. If the subject specific subject matter is one of court, but plaintiff had sued in any other court, then the play will be rejected and the plaintiff will have to file a case in court which is related to the that matter. So in case, for example, any victim, plaintiff is the person who filed case. So in this jurisdiction, subject matter jurisdiction, if a plaintiff case their file in court that is not related to their subject, then play will be rejected. And the person who file case have to file their case in a related court, means the court which is related to the matter. For example, a complaint regarding a consumer good should be filed in district consumer forum rather than district court. Means, for example, there is a case complaint regarding consumer good, it should be filed in district consumer form, not in district court. But plaintiff file their case in a district court, then district court will rejected it, and plaintiff have to file their case in district consumer. In same manner, all environment related cases tried in NGT rather than district court. So environment related means like a pollution related, the cases must be filed in NGT. And if somebody tried to file their case in district court, then the case will be rejected and they have to file their case in NGT. Then pecuniary jurisdiction. This type of jurisdiction mainly deals with monetary matters. We can say income related, money related. The value of suit should not exceed the pecuniary jurisdiction. So there will be a limit that must not be exceeded. There are various limits set for a court that can try a case of certain value beyond which it is tried in different courts. So there will be a limits and you have to apply your case according your limits. For example, this consumer can handle a case less than 20 lakhs, but if you want to file case 30 lakhs, then you have to go to state consumer, because state consumer can handle more than 20 lakh rupees but not exceeding 1 crore. So but if your amount is exceed 1 crore, then you have to go to the next authority, national consumer. So it depends upon the claim made in proceeding and it's structured in hierarchical order. So pecuniary jurisdiction based on monetary matter, and according to the limit you have to file your case in corresponding court. This is all about types of jurisdiction